I don't know how many of you find, ladies and gentlemen, get to practice in the state of Florida, but we had two big cases come out last year that we have actually were waiting on for a few years to get decisions from the Florida Supreme Court. The first one was the Castellanos ruling, which essentially dealt with attorney's fees, and it basically got rid of the attorney fee schedule that we relied on to determine the value of the separate attorney's fees that were entitled to opposing counsels once they secured a benefit for their client. Used to be that you would determine the attorney's fees based on the value of the benefit obtained. So if you were arguing over, let's say, a diagnostic, a lumbar MRI, and you actually went to trial over the lumbar MRI, you spent at least 20 hours on this issue, and opposing counsel was successful in securing that based on the way that the law was written. Previously, they would, let's say the MRI cost you $1,200 or $750, they would get 20% of $750, and then that was their fee. So what they were essentially arguing in Castellanos was that they were not, by using the value of the benefit obtained, it did not create a reasonable attorney's fees. And so the Castellanos ruling came down and got rid of the attorney fee schedule that we use, and now it's basically a quantum merit standard, which is basically just how much time they spent on the case, whether or not the time that they spent was related to the benefit that they obtained, was reasonably calculated to lead to that benefit, that type of thing. So we're really back to an old law type of situation. Obviously, this increases the exposure on your Florida claims by $20,000 in some cases. So sometimes it's just easier where we would have litigated a lumbar MRI before, and now you know what, we're just going to give it to you for diagnostic purposes and call it a day, because we don't want to take the chance of losing on something rather what we would deem maybe insignificant based on a cost-benefit analysis, because now we're going to spend $25,000 in attorney's fees. The interesting thing about Castellanos, actually, and this was the dissent opinion, was actually rather lengthy from the Florida Supreme Court, was there's no reasonable language in the Florida statute. There's no guarantee that attorney's fees have to be reasonable. So it was a stretch for the Florida Supreme Court to come up with that, which is why the dissent opinion was so strong and so long and well written. They did not believe that that should have been taken into account when deciding whether or not you were entitled to quantum merit or based on the value of the benefit. So, but until they change something, this is what we're stuck with. I'll go back, but this legislative changes that I wanted to talk about real quick was the House bill and the Senate bill that was recently introduced in the Florida legislature. They were trying to cap the hourly rate to $250 an hour. So, because depending on where you are in the state of Florida, you could go down to Miami and the attorneys are trying to get $425 an hour. Whereas if you go to the Panhandle of Pensacola, maybe $200, $225. And so I think the legislatures were trying, it actually sounded like a fairly reasonable compromise. I always say that I always have the saying though that fair is somewhere you take your pig. It doesn't really belong in the court of law. I'm from Tallahassee. So unfortunately these were just struck down. They did not make it. So this was like 10 days ago, so these are done. But when I turned this slide in, they had not been decided yet, so there was still the hope, fingers crossed, that this was going to go through, but they didn't make it. So we are still on a reasonable standard, if that's what you can call it. The other case that I just kind of went through real quick, and how do I go back? Can I? That was funny. See? I went the other way. No. Okay. Oh well. There we go. No? There we go. That's pretty good. That's fine. That's what I need. Okay. We did it. Anybody have any questions about the Castellanos ruling? So we're stuck with that for right now. There's been no changes since last year. The other big case that came down was Westfall, which is essentially got rid of, in Florida workers' comp, we had a 104-week cap on temporary indemnity benefits. A few years ago they changed it to include vocational rehab benefits, so that was nice. It wasn't tacked onto that, so it was 104 for everything. minus income impairment benefits. But they got, in the Castellanos case, they basically deemed that 104 weeks was unconstitutional because we don't, in Florida, we did not have the gap period. So if someone reaches their stat MMI after 104 weeks of benefits, but they're not at a point where their medical treatment has created an actual maximum medical improvement, there's room for continued improvement, then they're not really at permanent total disability status. So there was a gap of time where they could potentially not get any benefits. And so the court said that essentially that was unconstitutional. So now we're back to 260 weeks or 5 years of temporary indemnity benefits. And there was some scuttle as to whether or not that was just TTD, but it is TTTP. It's all of the temporary indemnity benefits. Essentially, we're back to the 1994 statute with regard to payment of temporary indemnity benefits. And there's been no talk of that going anywhere anytime soon. So, but I don't feel that this has had a gross impact on how we value a case necessarily as much as the Castellanos has. This doesn't really change how we value or look at exposure for future litigation as much as obviously Castellanos plays a big role, not so much the Westfall. So, but that's it. That's all we've got going on in Florida. It's been a slow year.